Hi, everyone. Good evening. Live here from San Antonio, Texas on a stormy night, Memorial Day weekend here. Today is Memorial Day, which marks remembrance for all those that gave the ultimate sacrifice, serving our country and the armed forces. So we respect them and all that they did and all the sacrifices made by them and their families. Also, shout out to those that are currently serving on active duty, also in the Coast Guard, protecting our nation around the world. And so just wanted to say that before we start out tonight. And tomorrow we got a much anticipated day of testimony. We're expecting the second expert from Aperture to testify tomorrow for the prosecution, and the prosecution may have that be their last and final witness. And if that's the case, then the defense can start their case in chief. So in looking at the first trial, the testimony of the two ARCCA experts, Dr. Wolf and Dr. Wrenchler, it's really, the takeaway I would say is very impressive. And I just can't imagine anything that they say that would be contradicted by anybody with any amount of credibility. So we have a Dr. Judson Welcher that's coming to represent Aperture. He is also working for the same company that we previously heard Shannon Burgess testify, him working for as well. And we know how that went with Shannon Burgess. His testimony revealed an ongoing year after year after year discrepancy on what his academic credentials were. And he never did get them right until right before this trial, but the defense was able to expose him as being an ongoing serial misrepresenter of what actually he has done towards a bachelor's, which is really essentially nothing since 2019. And so his testimony is really brought down by all that. All of his technical stuff he talked about, once you pose on and have a bogus resume or CV, curriculum vitae like that, how can anybody on the jury take you seriously at that point? And now we're going to have this Judson Welcher. Supposedly he's got a doctorate from University of Southern California, but he doesn't list the year on there. And in the bio narrative, it doesn't list anything about that either. So I'm just going to say I assume he has it, but he's surely not advertising it very well. And so we do know from what Hank Brennan, the prosecutor, represented in court a few weeks back, that he would have to have Welcher testify after Burgess, because those two were like interrelated. And so the fact that they're interrelated, I'm thinking, okay, that means that some of the baggage that we have from Burgess does have a carryover effect to Welcher as well. So this ought to be good tonight to cover what we had from the previous testimony. It's just like one of them is just over an hour, the other one's 40 minutes. And I found it on the trial channel, which cuts out all commercials. So let's start with Dr. Wolf here first. If you got questions as we'll go along, I'll be keeping track. I'll try to answer some of those. Can't answer all of them, but if you do have a question, please use a red emoji for that. So here we go. This is Dr. Daniel Wolf. He's got a doctorate in electrical engineering and computer science. I get the other tab here working. Here we go. You notice the tab here. It says,
You tell us whether the evidence given to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolf, last name spelled W-O-L-F-E.
Dr. Wolf, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCCA, A-R-C-C-A.
And what is ARCCA exactly?
So ARCCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCCA, correct?
That is correct.
What sort of contracts does ARCCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government, as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
I hope when they bring them on for trial 2 here, they're able to go into more depth about law enforcement agency support for that, as well as things like the National Traffic Safety Board, and going into the fact that they've supported major disasters like the Challenger space shuttle explosion over Texas and Louisiana a number of years ago, as well as the TWA Flight 800. They were doing a key role in that as well. So they're definitely the best of the best. And as I said in my last live stream, pretty much you have to have a doctorate or very far advanced in your field of study in this area of engineering and reconstruction. Otherwise, you're not even going to get in the door there with this place known as ARCCA.
Is there other clientele that seeks out ARCCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night. There's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolf, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle, pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you've just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD? Certainly.
So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object spatially without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction.
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it would probably be well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCCA to evaluate that.
Does ARCCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah, absolutely.
Part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Yeah, that's a good point, Kate. How ironic and ridiculous they had to be voir dired, Dr. Wolf and Dr. Wrenchler from ARCCA, and yet Burgess could just swan on in with no credentials. I mean, it's just a night and day difference.
Have you ever authored any peer-reviewed papers in the field of physics?
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle,
Jackson,
reaches...
may we approach?
Sure.
Now,
Yes, you
Thank
can
you.
move on.
you've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not.
I couldn't hear exactly who that was that objected. It sounds like Yannetti objected, but was that Lally? I didn't see, and then they cut out to a commercial break
hired by the
or a pause in the, I guess, a ceiling fan break.
defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Miss Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
One of the things I'd recommend when you got this caliber of an expert there, I would not talk as fast. This is something that normally my complaint is that things are dragged out too slow. The lawyers and the witnesses, they just sort of drag stuff out. They're not respectful of the jurors' time. And this is one of the times when you got to showcase, this is like the one anchor and foundation for your whole defense is these two ARCCA bookends. I would not be asking these kind of questions this fast. I hope whoever does the questioning of the ARCCA witnesses on direct, I hope they do it slower, because this is like so fast. I think the jury is not even digesting a lot of this. And he's not the kind of witness that sit there and just talk on and on and on. I mean, he's like succinct, to the point. He's not going to waste the jurors' time. So I think his pace, he's trying to match pace with Alan Jackson here. So I hope that they have a slow down pace so the jury can really digest what they're saying, because he's saying a lot of stuff and he's saying a lot of interesting stuff. And, you know, the jurors, hopefully they're taking notes down, but it's even taking notes down. There's a lot being to digest here on the substance of what kind of caliber of work these ARCCA folks do. So that's something I hope to see here at trial too, where it doesn't just go over their head.
All right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
What the heck difference does that make? The way he asked it, it's just nothing but another truth objection. As far as the Leslie versus Jackson, I wonder if my prediction is that they'll have probably a Leslie doing the experts for ARCCA and also handle the cross on Wrenchler.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you
All this kind of stuff is very critical. I would just ask it a little bit slower and have it asked a couple different ways that's not the exact same, to really drive these points home that they did not have a chance to meet and go over the testimony and have a lot of in-depth dialogue like you normally would with a defense expert, and that being because these guys were hired by the feds and the feds did not release them to answer questions. So they're pretty much going in cold for the most part here. So he's not sat down, interviewed them, gone over the questions to be asked and stuff like that in much detail at all, which is very tough to do, sort of doing it on the fly. But they got the overall report. So from that sense, Jackson knows his ultimate findings are that Karen Reed's vehicle does not align with doing the body damage to John O'Keefe.
was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us in.
Kimberly Williams, what's worse, deleted text or Burgess changing his CV? I'd say Burgess. Yeah, this is going to be so interesting. I think if Hank Brennan loses his cool like he did on the voir dire for these ARCCA experts, and like he somewhat crossed the line with the medical examiner. So he's just looking really, really terrible in front of the jury, and the jury's not going to respect him for that. And they'll actually gain sympathy for folks like the medical examiner and these ARCCA experts if that ugly side of Hank Brennan's type questioning is done here with these two ARCCA guys. So I think Brennan feels like he's going to lose the case with these ARCCA witnesses, and Welcher needs to be propped up. So I think he's going to be even even though he's realizing he's got to somewhat tame his tongue. I think he's not going to be able to control himself as much as he would like, and I think he's going to come across really bad to the jury.
Testify, correct?
That is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Wrenchler, and Scott Klein.
What was Dr. Wrenchler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Wrenchler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Wrenchler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you...
May I?
Sure.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
Mm-hmm. So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically,
No doubt.
when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is.
you get perspective that way, the depth of the scene. And then you can also do close-ups.
I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not.
That's what he's talking about. Think about the photographs of the shoe out there. We saw several different close-ups. We have no context, no measurements to how it is in relation to the curb. Sometimes it looks like it's next to a curb. Other times it doesn't. We don't know where it is in relation to flagpole. There's no measurement or markers.
Really having a great understanding of where was it relative to all of the other evidence.
Or when it got there.
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically that Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that theory of the case is, based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically that Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Why is that an objection? You're supposed to understand what they're saying Karen Reed is guilty of, and that is a theory. So this should be allowed.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Oh, sure.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yeah.
Also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper. More so on the wraparound section, as it kind of curves around to the right side of the vehicle, there appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is.
Yes, Denise Sanders, he did ask, have you been paid by the defense? Yes, that's past tense. He didn't even discuss it in the future tense, whether we would pay you or not. So he didn't have a chance to talk to them, from what I gather. And so there was no lies or deception in any of this thing that happened in the trial. So there's nothing about a grave concern that either ARCCA lied or that Jackson had lied during this proceeding here before a jury.
Positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think going back to the scene evidence, again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper, in the taillight housing, the taillight mechanism, anything from the car, from the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not
And keep in mind, the state lab folks couldn't even say whether it was all plastic or not.
have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you just...
Yes, Tammy, he knows that they're the best way to kill his case. And he can't do any damage to them on cross. They're telling the truth. He knows they're telling the truth. And that kills
describe
the
what that
case.
testing was?
So we performed, again, this is...
I should say it's already killed. This is the final nail in the coffin. Nails in the coffin.
With Dr. Wrenchler and I working together on this again, we performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Yeah, I think a lot of people, Sharma Lily, the way this Dr. Wolf was treated in that voir dire, where he had to make a special trip, even though he'd already testified beforehand, to try to play this gotcha routine between the judge and Brennan, was absolutely despicable. So yeah, I think there's a lot of strong emotions from a lot of people that saw what a sham this whole process is.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had
No, actually, Lexus is owned by Toyota. That's their premium luxury brand. So there's a lot of similarities. For example, the Highlander is really almost the same as a RX version, and what Karen Reed's vehicle was, which was the LX 570. That's actually like a Toyota 4Runner. It just has a different engine, bigger engine in it, but it's all made by the same type system, and they may have different plants, or some of them may be on the same plants where they run them parallel. But they're Lexus and Toyota, like I say, they're just a luxury version of a Toyota, because Toyota owns them, and they have a lot of the exact same type of vehicles. It's just that the body's different, and a lot of the options are more higher end on the Lexus.
an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Wrenchler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there.
It's like he's talking too fast, I think, for the jury to digest this the way I would want to see it done. So they're both talking too fast. They need to slow it down. And I think it'll be retained better in their memory when they're going back to deliberate.
You and Dr. Wrenchler formed that theory and wanted to test that theory, correct?
Yes,
You were not told that theory by the defense because you've never met us.
correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data. Got a broken drinking glass, a broken taillight. Let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
You can't get more independent than that.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow.
I think Lauren Johnson, you asked what can the defense do to minimize the jury thinking these guys are paid hacks? Well, I think they're the way they come across, the way they speak, their degrees, they have the type of clientele that shows they're world class, they're best in the business, and the fact that they got paid some for doing their line of work. I mean, I think it's also common sense. Common sense backs up what they say. That's not something that we will see with Welcher. If Welcher says something different, he's not going to have common sense on his side. So I think this is also leaning in favor of the defense here. And if they just come right out and they can bring it out on direct that, hey, how much you've been paid, if they need to do that, think about the fact that none of the prosecution witnesses or experts have been describing how much they were paid. So we had Dr. Wolf, the doctor from Miami. We also had Burgess. He was from Aperture. We've not heard how much they've been paid. So defense did not get in those kind of details. They tried to with Burgess. Burgess said he just didn't know, but Welcher should know. And Jacqueline Jace, how would I handle the direct to take this thing out of Brennan repayments, text messages? I wouldn't bring up the text messages. Let Brennan bring that up because he looks like a little crybaby. I wouldn't worry about it. Just bring up payments if you need to. This Dr. Wolf was absolutely amazing on the way he handled Brennan. He didn't let Brennan get it under his skin at all. He actually just sort of laughed and mocked in a professional way at Brennan. So I expect him to be able to totally handle himself and let Brennan try going after this guy, because Brennan will fold like a cheap folding table, and he's not going to come across as likable or credible as a prosecutor when he does this. He's already lost, as I've said before, his credibility with this jury. This jury should not be able to trust what Brennan says.
You were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel, would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed two.
There was some, it reminds me of some show that we see, God, what was that? Where two guys are always testing out myths and doing these kind of experiments like that. Anyway, I don't remember the name of that show. I don't think it's still around, but anyways, it's a really good way to replicate what kind of damage you can do to a taillight. So let's see how it turns out.
Two different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Wrenchler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, told you any specific, let me see if I can rephrase that.
Yeah.
Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Wrenchler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or
I want to hear that.
there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Wrenchler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason?
Why is that a problem, Lally? they're trying to come up with scenarios. They're given a drinking glass. They have the broken glass tail light, and you have an officer that's killed. Obviously, they understand there's somebody making an accusation that this vehicle struck John O'Keefe. Can you rule that in or out? Obviously, that was a general framework. They weren't just given a bunch of items and said, we're not going to tell you exactly what happened or what a theory is. We're just going to tell you to go figure out what might have happened. I think they were given at least some basic foundations.
Reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass in a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran 2 tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed or ultimately the end result speed to that. So what I will say, though, is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the
Yeah, because there wasn't as much discussion, it was really no discussion before he testified. They didn't get a chance to have a much dialogue, and that's what you normally do as an attorney. You're hiring an expert. There's a lot of dialogue going forth and back. What about this? Can you test for this? Would this test show something that we're trying to figure out? The defense or the prosecution in this case will be arguing such and such. Can you confirm or refute how that would play out through your different testing mechanisms?
the taillight, if you think about where the kind of where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits the
Share screen. Oh, I lost those tabs now. Yes, please. Hey, sorry, everybody. We just lost power here. We got this bad storm going on. We're under tornado watch. Sorry, everybody. We just lost power here. So, can you all hear me? No, I don't cover the trial live during the day. I just cover evening recaps. All right. Yeah, I hear thunder and lightning, and so I'm not hearing the best sound always with Dr. Wolf testifying here, but stand by. I'm going to have to wait a second here before I pull up the links. Yeah, here in San Antonio, they don't really have tornadoes much. They're pretty rare. And they don't usually have basements in the south, so there's no basement here. Okay. Okay, Suzanne, yeah, there's no basement to run to, but I'm on the second floor here. Stand by a second. All right, here's the link for Wolf. Okay. Stand by. Gotta check on one other thing. Okay, I hear thunder, but let's go ahead and proceed.
Directly at the tail light, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
So, like upwards of 40 miles an hour with a glass, like the one in question here, we've seen admitted in evidence and studied by the Massachusetts State Lab. That's 40 miles an hour. I mean, that is so fast. You cannot throw it that fast. So that's much faster than someone like John O'Keefe could throw. Plus, he was very, very much drunk that night, so he's not going to be able to throw it much at all.
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where the kind of where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits a static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were to the taillight were to make contact with a person holding a glass, would that replicate what you did in terms of you're firing a glass into the taillight? In other words, are they apples and apples?
No.
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5-inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Wrenchler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection. Sustained.
All right, let's go back.
In all the information, the taillight.
Are inconsistent with the injuries to the arm.
So given everything.
So there you go. It's inconsistent. I mean, he should say be able to say there's no way those injuries on his arm came from anything have to do with the tail light. But here in this court, you can't do that.
Your investigation was revealed concerning this testing. Are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection. Sustained.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Testing.
Ridiculous.
Are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection. Sustained.
I gotta. It's so fast. I gotta play it again.
It's inconsistent with the total length of the arm. Axis, again, is confined to just that roughly, again.
These are such critical points, and Jackson's talking so fast, and so it's just way too fast for a jury. I wish he'd really slow it down.
We're talking about the taillight itself, that 6.5-inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr.
So the total length of the arm, because having those horizontal gouges, scrapes all the way down the arm, doesn't match anything on the tail light, period.
Dr. Wrenchler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
See how fast he says that? Are you saying
that your investigation was revealed concerning this testing? Are you saying that the taillight was damaged by John O'Keefe holding a drinking glass
tail light was damaged by John O'Keefe holding a drinking glass
that was hit by an SUV?
That was hit by. So this has nothing to do with throwing it.
Objection.
Sustained.
Why isn't that allowed, Judge? You know what the answer is, and that's why Lally is objecting. He knows what the answer is because he's already seen the report, and the judge doesn't want the truth coming out. It's plain and simple. That's how innocent people get convicted with this kind of ash and trash going on in a courtroom.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
I'm just going to say 40 miles an hour. He's a pitcher. A glass is not an easy object to throw. It's not like a baseball. Yeah, you could easily throw a baseball more than that, 40 miles an hour. But I'm saying if you're drunken state and the glass is not easy to hold and wind up and throw it. So I don't see how it could go 40 miles an hour. That's my take on it.
Sustained.
Your approach.
Yeah, it's just, yes.
Yeah.
What information?
Why even have these guys show up as experts if you don't allow these kind of questions to show up? These are routine kind of questions that should be asked and answered for the defense to be a part of their constitutional right in showing that Karen Reed is falsely accused.
If any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe had a pneumatic cannon with him?
See, the audio's not as good here, so I don't know what AJ's doing, but we're sort of losing his clarity and voice here.
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop testing.
Certainly. So, again, through discussion with Dr. Wrenchler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why'd you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
Yeah, I mean, I think you might be right, Leslie and Melanie. Maybe the trial channel is speeding it up, so I wish they'd informed me of that. But
And what was the significance of 15 miles per hour?
so that's good. So if this is being played at like 1.25 speed, then that's not as concerning then, and it would be more of a slower pace if this is going to proceed for trial 2.
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Wrenchler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with the vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do, 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion with following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck and the taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if I were to ask you whether or not there would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what is your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint.
Well, I think he understood it was truth coming out. That's the only thing he understood. It wasn't a legal basis to do it, though. But I get what you're saying. He had no legal basis to object, but he doesn't need to come up with one in this type of court.
Point, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15-mile-an-hour test.
Which means 2.5 more times the damage to the taillight,
Certainly.
which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of?
Jubilee, you're asking why even talk about the glass being thrown on the SUV if they didn't know how it happened. Well, they knew they had a broken glass. They knew they had a broken taillight. So I think it's normal deduction. Okay, well, was there any kind of interaction between these two things that could explain how they both became broken, but then where the glass was also found doesn't make any sense if it's found near John, and we have no idea. There's so many things they don't know about this scene. They don't know, did the Lexus actually back up? Did the Lexus, if it did back up, did it stay on the street? Did it go up in the grass? How would have John not been able to see it coming at him if it was really coming at him? There's so many questions. You go down all these different rabbit holes. You just don't know. None of this stuff adds up that the prosecution's saying happened. And we still haven't heard the exact details of how he was hit from the prosecutor. We still don't know. And they're going to try to wrap it up with Wrenchler tomorrow to explain how John was hit. Oh, so like 6 weeks in, we're going to finally hear how this supposedly happened from this one Wrenchler guy that's affiliated with Burgess. It's not going to be credible, I'll tell you that.
Of the taillight, specifically from where it meets the lift gate to the left side. I'm sorry, to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really, it's even though the taillight continues, it's not projecting out on the back end more. It's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
Oh, please. Yeah, ask another question. We're getting too close to the truth here that exonerates Karen Reed. Yeah, Sharma Lily, you're saying you're already convinced, but hearing that the glass and the taillight didn't match, there's no explanation other than it was planted. So how can you still believe Karen did this is beyond me. That's a good point. The glass does not match. And the hair being able to stay on that side of the car through all that kind of horrendous weather, I don't think so.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the lift gate, as I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the lift gate itself. And And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Right, not just the tail light. There's to be a lot more damage, and the arm would be really messed up. Not just having all these bite type marks on it.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure on your objection.
Oh. Ava, you're saying, why did the jury believe he was hired by Karen's insurance company? Was it because when he was asked who usually hires you, he listed different companies, but he started off with insurance companies? Well, he mentioned insurance companies and law firms like very soon before he went into other federal agencies. So I would have liked to have him, if he was my witness, have him switch that around, even though most of the work is done with insurance and law firms. I think to be able to say, our firm does significant work for multiple different federal agencies, and then go on down the line.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
I agree with you.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about,
That's just common sense, folks. If you would have your arm sticking out and a vehicle hits it, you're not going to be propelled and launched like you would be if you're walking across, let's say, a crosswalk, and a car doesn't see you, and you get flipped up because they hit you below the waist, and then you're spinning around and being catapulted up over the vehicle, let's say. And so anyway, it's a lot of it's just common sense, I think.
the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of the damage that you described, the absence of damage that you described between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an arm, an outstretched arm of a human being?
Objection.
This is totally legitimate. What's the answer? We need to know. Because they're going to try to say his arm was struck by the vehicle. None of this damage is consistent with an arm strike.
I'll allow that.
That would be inconsistent, in my opinion.
Well, I'm playing it to 0.75 speed because normal speed, it's too fast. And I believe some of the comments that this did not occur that fast, and I don't remember it occurring that fast when I stopped to think about it. So that's why I slowed it to 0.75 for this purpose tonight.
They have just a moment, Your Honor.
Yes.
And what is your opinion, Dr.?
He's talking over his head. Well, see, I think what is important to do is show pictures and have diagrams and all that kind of stuff. So talking about all this stuff without showing it and having, I guess they call them chalks up there, and I guess the judge didn't allow chalks, but you really need to explain this, and then have, if you don't have chalks, then at least have photos you can have admitted to the jury, or at least show it on a through the witness and have him hold up the photo while he's sitting there. If you had to do it that simplistic and not even have it on a bigger easel, and then show these kind of photos to and have them walk through and say, see, you can tell here from this back tail light, there's no other damage other than this tail light. It's not the kind of damage you'd see from if it was a glass being thrown at it, and if an arm was struck by that, you would not see. You would definitely see more damage to other parts of the vehicle. And oh, by the way, he would not be catapulted and be spinning around as we heard that ridiculous version of events from Trooper Paul.
As to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight, if in fact that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm.
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
Well, he has all his questions scripted out, so I don't know why he would laugh like that. I don't like attorneys laughing, and I guess he wasn't laughing, but he's making a joke about it. This is too serious. You should never joke on a murder case about something like this. I don't know. I just don't like to see that.
I'm trying. Physics, that's why.
I don't like the witness, laughing and smiling that much either, because I know he's under pressure and whatnot, but just you just lose the professionalism. And so I just think it needs to be handled better by counsel when I see this kind of thing going on.
From your testing, what would you expect to see in terms of the damage to the right rear taillight if in fact that taillight were to make contact with a part of a human body, for instance, an elbow or an arm at 15 miles an hour or above? What would the level of damage be as compared to the damage that you actually saw?
Well, if
That's a good point. Bless Mom from Texas. There was total lack of preparation, or virtual lack of total preparation available. So this time they can. So they're going to come across much more detail. Hopefully they'll be able to show different diagrams and charts and photos describing how they came to their conclusions and pointing out what you'd expect to see that wasn't there on the back of the SUV.
If we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe on the head?
Objection.
Sustained.
Well, why can't they ask that? The prosecutor, if this conclusion came back and said, yes, this is consistent with striking John O'Keefe in the head, they would call and the judge would admit it. So the fact that it's the opposite, that it's not consistent with striking John O'Keefe in the head, then that's objected to and sustained. This is how low of a level this court has gone to depriving Karen Reed of the truth from coming out of this jury. It's absolutely disgusting. And keep in mind, this is trial one. So this should just infuriate the defense lawyers if they see this. They need to strenuously object, call a sidebar, and be arguing Supreme Court case law. That's what I'd be doing if this was my case in Texas and I was dealing with this kind of a gauntlet.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe from the head or the arm?
Objection.
Sustained.
What's the point of even having an expert there? This is like the ultimate question. Is it consistent with? So is he going to, maybe she's going to say, well, you can only say whether it's consistent with or not. Why can't you say the ultimate thing? That's really what the jury needs to do. Consistent or not, that could be like a 51-49 type. Yeah, a little bit more, a little bit most likely. This it's consistent. Well, how consistent? It's consistent to the point that there's no doubt in your mind that no, John O'Keefe's body was not hit by the vehicle, and the shot glass or this glass, drinking glass, did not cause the damage to the tail light.
May we approach?
Yes.
You are muted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your
So that's it. You can only say consistent or not, and that's such a watered down, I think, a disgrace, because it's the truth is significantly being kept from this jury, this first jury. So
expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
Morning, sir.
Good morning.
Now, you, in conjunction with, I'm sorry, Dr. Wrenchler, is that correct?
Dr. Wrenchler, yes.
So you, in conjunction with Dr.
Keep your voice up, Mr. Lally.
Yes. You, in conjunction with Dr. Wrenchler and Dr. Klein, wrote a report in regard to your analysis here, correct?
Correct.
And doctor, that report was
I don't think I want to listen to 29 minutes of his cross-examination. Because what he said is totally unimpeachable. All right, so now I'm just going to delete any further review of this. And let's pull up Dr. Wrenchler.
You solemnly swear the evidence given to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
May I depart?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record?
Certainly. Andrew Wrenchler, Renschler.
And what do you do for a living, sir?
I'm a biomechanical engineer and accident reconstructionist.
Yeah, Patty B. Can Hanks, you want Hank to say in a reasonable degree of scientific certainty. Why is that okay? Well, then that's something the defense should also do. If that's what the judge prefers for her court to say, then yeah, this rather than saying consistent, I would like to have better reasonable degree of scientific certainty, and maybe try to get both in. All right, here we
Who
go.
do you work for?
I work for a company called ARCCA LLC.
How long have you been in that position as working for ARCCA, first of all?
I've been with ARCCA for about 16 and a half years now.
You indicated that you're the director of biomechanics and human factors. Is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say crash injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be, in a crash motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body. I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and professional classes with respect to biomechanics as well as action reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know...
So he doesn't treat injuries, but he recognized the kind of injuries that mechanics of objects and people being hit by things or being flung into things, all those kind of things has to do with mechanisms and engineering. And that's what he's being called for. So let's watch it to see how much of the truth the judge blocks on this guy.
The dimensions and size, and you apply a force, it'll bend and break. We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or intervertebral disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor?
There is, yes.
In terms of injuries?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are. And then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, anywhere there's an interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not diagnosing an injury as much as you are trying to figure out the mechanics and the forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't diagnose an injury, but given an injury, I understand the mechanics of how that injury is produced and what you need to actually cause that injury to happen.
Are you also published in the field of biomechanics and or engineering?
I am, yes, sir.
Can you describe that?
When I did my graduate work at the University of Pittsburgh, I worked at a place called the Human Engineering Research Lab. and it was associated with the VA in Pittsburgh as well as the University of Pittsburgh. And so we looked at people with disabilities. Well, one of the big things that we did, or one of the major points, was people in wheelchairs. So if you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events. How can we reduce the force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
Have you qualified as an expert in the past in the area of biomechanical engineering and human factors?
I have, yes.
Hey, I can tell you the other half dozen, the more qualified they are, the less pretentious they need to be. I can tell you that for any kind of discipline, any kind of professional field. It also carries over in the military. And those that are posers are the ones that are doing all the rah-rah, strutting around, sticking out their chests, acting, sounding tough. The real door kickers, as we call them, the guys are not just sitting doing desk jobs, sort of like I was as a lawyer in the military. The real guys are doing out there the door kicking, daily going out there, putting their lives on the line. They're the ones that don't brag about it. They don't act tough about it. So you really can tell who's really in the line of fire by the way they act. And so they don't have to act and be a hologram, as I call it, or be a peacock strutting around. Then those are the guys that really know what they're talking about. They're not worried about trying to impress anybody. You can tell this guy and Dr. Wolf, they just know their game. They're not trying to impress anybody, and they don't need to put stuff on their resume that if they get called on it, they suddenly have to change it and strip stuff down for credentials and academic degrees.
In furtherance of, let me ask it this way. Were you asked to engage in an analysis, ARCCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You've never heard of the Karen Reed case.
I had not, no, sir.
You were contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I never discussed the substance of your testimony, correct?
That's correct. We have not.
Would you consider that your analyses, your conclusions, and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
Boy, she sounded happy to sustain it. Let's go back. Replay that.
Discuss the substance of your testimony, correct?
That's correct. We have not.
Would you consider that your analyses, your conclusions, and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
How is that sustained? Oh my gosh, this is unbelievable, ridiculous. Wow. I'd go up and have a sidebar. There's no way I'd tolerate this as a defense counsel if I was on a case like this in Texas.
You've not been paid by the defense, is that right?
So you gotta fight back. You gotta fight back this so-called court of law. Massive injustice here. Kyle Wells, defense missed a prime trolling opportunity by not asking the biomechanics expert what a body must be doing to induce a button on an iPhone. Yeah, I think that's common sense, especially with this younger jury, but hey, maybe give it a shot. But they didn't have time to prep, so I think they're just trying to go for the card. They thought this whole thing with ARCCA is an open and shut case. They don't need to go into the phone stuff. That's probably what they're thinking. They maybe didn't even think about it.
I have not, no, sir.
And you do not answer to us in any way.
I do not. That's correct.
You indicated that you and your team
Oh, that's true, Julian Nielsen. Dr. Wolf's, on the other hand, he was talking about his summa cum laude. Yep, that was not asked. He also called himself a brain surgeon when that's not what the terminology the doctors in the medical profession use. They use neurosurgeon. So
were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail light.
I mean, you can just tell the juries can pick up these two ARCCA guys. They're just telling it like it is. They know their craft. They have the utmost credentials, and they're not going to sit there and skew something just to become a witness in a case. They have enough business. They're not worried about compromising their integrity just to help a particular client out.
The incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolf, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Yeah, they confer and they compare notes, but ultimately they have different lanes of analysis here.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we.
Oh, thanks, Laura. Appreciate you.
Perform testing to evaluate the strength of that taillight cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that. Just generally, Dr.
Generally, don't get too
Yes, Your Honor.
specific. Oops, that support your. Oh, brother, I lost this. Hold on.
Step right up and step on me.
I don't know the timestamp where I was at. Let me just try to take a stab at it here. Sorry.
Kind of force multipliers require a hard and rigid surface or not?
Explain the force is mass times acceleration.
Okay.
Reason is that to get the injury, it was a medical records. Medical was based on certainly the medical records, the description of what the injuries were.
Let me back up a little bit here.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
Lally, sit down. You're a disgrace to justice.
Allow that. Just generally, doctor, if you would, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or an extremity? 1,000 pounds of force because of the speed of the vehicle?
Well, force is equal Newton's second law. Force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. Mm-hmm. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the taillight, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough.
Can you imagine how messed up your back would be if you got hit in the back of the head? Plus, as we heard from Dr. Wolf, there wasn't a really sharper type of attack on the back of the head because there wasn't much of a depression. So 9,000 pounds of force against the back of the head, you're going to have massive depression of the skull. So that also proves, if you combine this along with Dr. Wolf, that proves also that the vehicle did not hit the back of his head.
Enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if
You know, I'd call the judge out on all this rocking and swiveling around. That is so unprofessional and unbecoming of a judge. You got this kind of serious murder case going on, and that's the kind of respect you have for the decorum of this courtroom.
If you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear taillight. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Look at how eloquently he says that, and look how smooth he is talking to a jury. He's just being himself. There's no pretension. There's nothing phony about this guy at all. And this should really be hitting home with the jury. And I just don't see how anything he says could be something different than Wrenchler would testify. So Wrenchler, what's he going to do tomorrow? Is he going to say that these injuries are consistent with being hit in the back of the head? Well, then you got another expert contradicting another expert from the Commonwealth. So the Commonwealth's experts, Wolf and Wrenchler, would be contradicting each other. So they're in a hot mess. Commonwealth's in a hot mess. They got no case.
Shifting to the arm are the same forces at play if instead of the head making contact with the taillight, it's an outstretched arm, for instance, at the elbow area of a human being, a person 73 inches tall, weighing 215 pounds.
Objection.
The objection sustained. Ask me differently.
Sure.
Oh, please.
Shifting to the arm are the same forces at play.
So you don't want to bring out the specifics of John O'Keefe's size? He talked about different parts of your body that be struck by a vehicle can have different effects on them. Obviously, the weight and height of him matters. Oh, no, now I lost my spot again. Darn it. I need to quit using my mouse here.
To have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing at 15 miles an hour, where we dropped the head form. So that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage.
Look at all that rocking around, moving around. I mean, golly, this is unbelievable. Yeah, she's basically trying to draw attention to herself with the jury instead of the jury looking at this expert. I just never seen like it. This is so bad.
Damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So
I'm telling you, ARCCA having more chance to talk to the defense, find out what more details are about this case. They're going to do even better this next go around. And the judge, let's see how much he tries to keep out. Yeah, it is very distracted because it's what happens when you put somebody on the bench that shouldn't be there.
So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting to the arm are the same forces at play if instead of the head making contact with the taillight, it's an outstretched arm, for instance, at the elbow area of a human being, a person 73 inches tall, weighing 215 pounds.
Objection.
The objection sustained. Ask me differently.
Sure.
Unreal.
Shifting to the arm
Backward.
are the same forces at play if instead of making contact with the head, you make contact with an arm, an outstretched arm.
They are. You know, I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does actually, almost identical, because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling at 24 miles an hour, sorry, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
Allow it. Watch the leading.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward in a standing position onto a rigid surface?
That's certainly one of the possible scenarios. That would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly
I'll just say this also, as much as I've been critical of the judge, you guys, a lot of you call her Auntie Bev and things like that. I think that is like an endearing term. So I understand why you guys call her that, because that's what somebody had referred to her in a Facebook post where they're renting a cottage her and her husband own. So to me, this sort of like, it's downplaying the significant damage she's doing to the constitutional rights here of Karen Reed by calling her an endearing term like Auntie Bev. So I'm going to give her the deference of a judge that she has, just by the fact that she is a appointed judge there in Massachusetts. But so I'm never going to refer to a judge, no matter how bad they're conducting their court. I will always refer to them as judge in their last name. So anyway, I just thought I'd let y'all know that if you notice anyway, when instead of saying Auntie Bev, if you have a question, I always convert it to Judge Cannoni, and that's the reason I'm doing it. So it's twofold reason. Number one, I think it's required of me as a professional in law, and number two, I think it's not shown respect for her position, and number three, I think that you're basically making her sound endearing, which she's not being endearing to the rights of Karen Reed. So anyway, for what it's worth, I throw that out there.
Scenario where you could produce that damage if someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, I think you may have just answered my question. Those kinds of force multipliers require a hard and rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete. No.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries, I want to shift back to the arm. I know I'm going back and forth, but bear with me. Talking about.
Yeah, I wish you would have asked him, though, right then and there, so none of these injuries to the back of the head are consistent with even falling and hitting your head on the back of a grassy, snowy area.
The arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous slash.
So this next go around, I'd ask him, well, how much at 20, if it's 1,000 at 15 miles an hour, 1,000 pounds of force per square inch, what would it be going 24 miles an hour. Is it proportional? Is it exponentially going to increase the faster you go? I know, like, the faster you drive a car, it's not a linear increase. Sorry about that. It's not a linear increase. There I go, hitting the mouse again. Sorry about that. Did I lose a screen? I guess so. My gosh. Okay, hold on.
Car at 25 miles an hour, there's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of
I want to make sure I got front up back.
Bear with me.
That's certainly one of the possible scenarios that would create the injury mechanism. You fall back 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling at 24 miles an hour, sorry, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
Allow it. Watch the leading.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay.
What are those reasons? I would ask the
back
follow-up.
to-
I don't know why he didn't ask the follow-up on that. I think because he's following the script and he's not thinking about how he just gave me different avenues to go on. So I think that'll be improved this next go around. Whoever's going to do the direct on
The head injury that you saw, was the head injury that you saw consistent with falling backward in a standing position onto a rigid surface?
That's certainly one of the possible scenarios that would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage. If someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, I think you may have just answered my question. Those kinds of force multipliers require a hard or rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries, I want to shift back to the arm. I know I'm going back and forth, but bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most.
There's still not enough Haley hopes that you're saying that Hank's going to say that Karen sideswiped John and caused him to slip, fall, and die. That's the only way the SUV wouldn't have much damage. She's going to use ARCCA's own words against him. I don't think that's using their own words against him, but I think that's what he's most likely leaning towards. And so we've not heard that directly yet. He's not said in his opening directly how this happened in any kind of great detail. So, but like he's saying, he's even covering this. Dr. Wrenchler is saying that the grass is enough to cause a fall that would damage his back of his head and crack his skull like that. So it still doesn't add up. No matter how they try to twist it around and contort it, they cannot get a reasonable explanation for how John O'Keefe got these injuries by Karen's SUV.
Most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous slash.
I wish it'd be like holding up the actual taillights and stuff like that rather than even photos. Just hold up, bring in all the exhibits that have been marked in the evidence, these different ones that have been put together. And anyway, that's what I think would be helpful to explain it, give them a lot better for those that are visual learners, better understanding of what this great expert's talking about.
Lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs
Look at all that moving around by the judge again. It's just unbelievable.
of the arm in this case, of John O'Keefe's arm in this case, correct?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
All right, let's go back.
You reviewed injuries having been struck the arm in this case.
Simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of John O'Keefe's arm in this case, correct?
I did, yes, sir.
All right. Were the
This is
injuries
huge.
that you saw on John
Right.
O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
Look at that. This is the ultimate issue that exonerates Karen Reed and Lally objects. Wow. I'm sure Morrissey told you to do that, right, Lally? This is disgusting as a prosecutor to try to keep out this direct evidence that can completely help exonerate Karen Reed.
That's sustained, Mr. Jackson.
You reviewed injuries specific to John.
See, they're not aggressive enough. They should have done a sidebar. This is so egregious, so much a violation of due process. It's just absolutely asinine, insane, crazy to see this kind of stuff going on in a courtroom.
Correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
May we approach?
Yes.
Okay, finally.
If you were to presume, for purposes of my question, that an arm was struck by a vehicle taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions?
Yeah, that's true. Comprehensive explanation from a very relatable, engaging engineer. They don't all communicate this well. I know quite a few engineers. Yeah, these guys are very, very good at communicating. And from my experience working with engineers, for the DOD, I can tell you they're not always good translating what they have on their minds onto paper and having it make sense, especially if they're trying to explain it to a layperson. So they're super smart, super brilliant. And so yeah, these guys, they're really great. I'm curious to see if Welcher comes across as relatable and as great a communicator.
Abrasions with no reason?
Objection.
Or just what would he expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing.
Yeah, I'm telling you, this from my experience with jury trials. If you get one cop as a foreman, he can just tell it, basically just pick apart everything, and he can just own the room. He can basically own the room with those others. If they're all just follower types, they're not going to be the types that are leaders and stand up to the cops and, hey, wait a minute. You're trying to help protect your buddies. This is what the evidence shown here. Listen to what ARCCA is saying. And he basically I think, used the word distractions or distractors to describe everything the defense presented. And that's why I think that one juror, Ronnie, was just basically parroting back what he was saying was what a number of the jurors were thinking, and when really I think it was just what this one foreman was trying to get to feed the minds of these other jurors.
Or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration.
Haley hopes, how can Welcher be willing to make himself look so bad by going up against ARCCA and telling them that they're a failure? He's not going to say they're failures, but he's going to have different conclusions. And yeah, I think he's going to make a fool out of himself. I don't see how he can contradict anything these guys are saying. All right, let's hear the rest of what this guy is saying here.
It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues.
And you'd also have DNA all over those polycarb pieces, which, of course, there were none or none tested either way.
Moves forward and pushes the arm out of the way. I didn't see any of that. Basically, just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be of the same force, generally the same direction, and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. Yeah. I mean, size is a big part of it. Certainly. Yes.
Did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width, if you can recall?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Let's go back to this.
Extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
He could have asked this question with better explanation what he's driving at, but he's trying to talk about consistency of the injury of John's to what we had for the tail light. So that is totally within the sphere of what his testimony should be about and his background is about. So again, we got due process violations. Let's see how this is going to be recovered here.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to see an initial point of contact, because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, an engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle at say 25 miles an hour and the body, the center mass of the body to be projected?
Objection.
Ask it differently.
Is it
Wow.
consistent in your view with
Ask it a different way.
engineering principles and physics principles that you know if an arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's out, and we have contact to the arm. I mean, first of all, it's a ball and socket joint. So the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle. So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, the complete body over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body 20, 30 feet, what injuries would you expect to be produced on that body?
Objection.
Sustained.
Wow, this is ridiculous. Yeah, so it's sort of like, think of any object where it has, let's say, branches sticking out. If you're going to talk about a tree, if you have a 5-foot tree in your house, it has some different branches sticking out to really knock it over, knock it far. If you just hit a branch is maybe going to turn it a little bit. It's not going to completely launch the whole object. Same thing he's talking about here with the human body. So it's considered like a branch of a tree in comparison to an arm of a person standing there. If their arm is out, like you got a 5 or 6 foot tree and they got branches sticking out, it's in a pot. If you like hit it with something, it's not gonna completely knock it over if you got a heavy pot. But if you got more of the trunk of the thing being hit, then you could launch the thing. So same kind of thing with the human body. It's just common sense kind of stuff. So that's what I'm wondering is that how can Wrenchler defy stuff like what Dr. Wrenchler is talking about? That's just common sense.
If you did have a body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
Last time, see, she wanted to shut this down. He's getting great testimony out to help Karen Reed's defense. Little Miss Red Velvet, what do I think of the fact the defense has paid them for trial 2 will make a significant... Why would it make any difference? Prosecution witnesses that are experts, they're paid. We don't know how much they're paid. Hopefully we'll find tomorrow how much the Aperture folks are being paid. But that's a normal thing that's brought out. That doesn't make them a paid hack or anything like that. You can find a paid hack by giving enough money to folks that don't have solid credentials and have to lie about their credentials.
May I interrupt?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck center mass with enough force from a vehicle traveling at whatever speed,
Yeah, an expert should be given different leeway than a regular lay witness. And Brennan, yeah, he does completely leading all the time, especially on redirect. So it's just nothing but a double standard between the prosecution and defense, trying to hamstring them every chance she can.
To project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne, and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that in this case.
Objection.
May I have a moment, Your Honor?
Yes.
All right, let me go.
Thank you, Your Honor. I have nothing further to say.
Ms. Tuali?
And
You would usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that in this case.
Objection.
May I have a moment, Your Honor?
Yes.
Thank you, Your Honor. I have nothing further to say.
Ms. Tuali?
Okay, I don't like ending on an objection and then you don't have anything further. So I wish, or I hope that doesn't happen this go around. So, all right. So I'm not going to listen to Lally anymore on this one because these guys are unimpeachable. They're rock solid, credible experts. And this firm, as I said in the last live stream, if you compare the background of the folks for ARCCA versus Aperture, it's hands down. ARCCA is so overqualified compared to most other type accident reconstruction firms. Half their folks have PhDs. And so we went through some of that last time. I didn't go through enough of them. So, some folks even complained I didn't pull up any photos of the females they have working there, but half the females also have PhDs. And some, as I said, some of the males have PhDs and PE licensing, professional engineer licensing. So it doesn't get any better than ARCCA, and I think it shows here through these two witnesses. So I'm going to jump down to new comments here, 1137. Oh, thanks, Jax. Nana. Yeah, I'm just staying up late. My wife is working late, doing billable work. And so I just figure I might as well jump on here. So Leo's doing good. Others as well. All right, let's see here. Born a Hawkeye, this is something they need to push for. They should be able to say it's the FBI and Department of Justice, but they got to try to get that out some way and make it clear to the jury that so they don't think it's insurance that hired them. And yeah, they've said other investigative agency outside MSP or CPD. Yeah, I don't know if she'll allow that though with these guys. They need to push for it, try to get that out there. Yeah, Dana Watch has passed. No relation to the author, John Steinbeck, but I got a brother, John. Brittany, how would they get in it? Well, they have to just keep fighting for it and call out the prosecution's hypocrisy. If ARCCA came back and said, yeah, everything lines up with Karen's SUV hitting John's vehicle, the damage to the vehicle lines up, where the debris field was, and the injuries to John's body are all absolutely 100% consistent with each other, everything aligned, perfect alignment, all these things. You're telling me they wouldn't want to bring out the fact that these guys were hired by the FBI? Of course they would. Yeah, I would just go into more of their clientele, how the firm, even though he hasn't done, like Wolf or Wrenchler hasn't done maybe work for the TWA Flight 800 or the Space Shuttle Challenger, bring those up as prior clients for the firm. Yep. Dito, Detective Olivia Benson. I didn't feel like the defense got as much out of ARCA as they could have. If they've been able to prep this time, will be different? You hope and pray. Yeah, I think it will be. Yeah, they had to can only say the agency, not which agency. That's true, Clayton John. Defense doesn't need to prove anything. They need to bring that out as well. Hammer that home in closing. PJ Wright, ARCA's all class, world class at that. Yeah, I think that they need to have visuals with experts. If you just get up there talking about it, this is not going to be a grand slam. If you have visuals with these experts, it's more of a grand slam. You just fall sort of flat as this testimonial that doesn't have the visual component to it. Yeah, concerned citizen, you're saying the keyboard shortcut, spacebar will pause. Yeah, I'm using that some, but the problem is I'm already on my mouse because I can only scroll through your comments with my mouse. So I can't use the arrow bar on the StreamYard app. So it's an online app service I'm paying for. So yeah, the judge last time didn't allow visuals, talks as they call them up there. Hey, Broken Baker. Yes, let's get chalks with ARCCA. Been chatting with your staff here today. Via email, that is. You're up in the Netherlands, so yeah, it's really early in the morning for you. Yes, Jam, it was good to see his testimony again. Confirms the point, no collision from the opening statement. Sherman Lilly, the judge and Brennan are trying to convict Karen on emotions and manipulated evidence. I think the jury understands the fact that the prosecution and judge are treating them like they're absolute idiots, that they have no critical thinking skills. That's the only way Karen could get convicted. It's the only way. And I don't think they're going to fall for it. I think they have the intelligence to see they've been gaslit for, what is it, 6 weeks now? Marcy, yeah, I think Brennan's temper tantrum was due to Dr. Wrenchler not completely agreeing with John O'Keefe was hit by a car. Well, no, I think it's also, we don't know what he's going to say. And so I would think that he's going to say that he was hit by the car. I don't know why else would they call him. But then again, this Commonwealth's case has been so bizarre because every witness they call practically is either neutral or damaging to the defense. I mean, the prosecution. So every single day the defense has won. Every single day throughout 6 weeks. There's not a single witness that has done them damage. Boy, some of you guys are up at 4 a.m. Wow. Yeah, I think the jurors are going to be smarter, even though they're younger. They're not used to seeing maybe it's the kind of corruption. Maybe they don't think it's big a deal to have liars in the government positions. Hopefully, they understand freedom and liberty and what the government's doing here, denying due process. They're picking up on all these things. I just don't know how this cannot be a full acquittal across the board. Tammy Manor, yeah, I think the jury's going to has an ongoing dislike of Brennan, and I would say, how many of them would absolutely disgust him and can't stand to listen to him talk? All right, in light, you're saying you didn't watch the first trial, got into the second trial. Yeah, I think they're going to do a lot better. They're going to do visuals more this next go around. So it's just going to be an absolute slam dunk. They're going to crush it. Sweet Kitty. Yeah, it was his right arm. Think of the orientation to the back of the vehicle to get the damage on his right arm. Yeah, it just doesn't align. Those kind of marks on his arms are something you'd get from a dog bite or dog claw tear on your arm. Jenniferous, yeah, Commonwealth's trying to turn lies into truth. That's the way it looks. I mean, if the jury cannot see that they've been bamboozled, hoodwinked, and taken for an absolute idiotic fools. Wow, I don't know what to say. Yeah, body language interrogation. Yeah, the judge is going to try to be extremely restrictive again. So you could try to do something similar. Currently working one. Technically, I don't think they're being paid by the FBI now, so that wouldn't be appropriate unless there was some other case. Process is punishment. Y'all thought that in 1.0 we were gobsmacked. Yeah, but you also had a cop as a foreman, so he could just totally control that whole room. Jinji, John was beaten up, not hit by a car. I think that's self-evident. Detective Olivia Benson, and yet the chats on the pro prosecution think the case has been completely proven, that her guilt is obvious. It's crazy. Yeah, it is insane. I don't really listen to any of that. And a lot of them don't even know the facts of the case well, and they're just sitting there spouting off. Brittany, yeah, no dirt or grass on his head either. Caroline Forth, okay, you think a younger jury, meaning in the 30s and 40s, which would be my age group, will get it 1,000% more than previous ones, assuming it's not rigged. You haven't talked to one person that thinks she's guilty. Okay. Have you noticed also how much hate there is on the anti-Karen Reed folks side? I mean, there's many of them are just like rabid, insane, crazy, and they are just nothing but insult after insult in their comments. It's all personal attacks. They don't have any professional, educated, intelligent questions or points to make. It's all personal attacks. Yeah, and the foreman also didn't allow them to ask questions. They wanted to ask questions. Hey, what about these other charges? Because this foreman made it sound like they couldn't agree on anything, and yet they had 2/3 of the charges agreed upon. So what a disaster. The judge should have inquired more about that. She didn't. She dropped the ball. Everything looks so shady in this court. Trial one was shady. This one's all shady. There's no due process here. This is not what our Constitution stands for. Yeah, Lynn Downing, your stand defense done so well. It's easy to forget they haven't even started their case. Yeah, please keep your comments clean. I don't like seeing people dropping F-bombs, and even if it's an acronym or your name or something like that, please keep it clean. Stevie Howell, have I ever seen an expert crash out like Burgess? No, I haven't. I mean, that's the one no an expert knows. You don't mess around with your resume. Yeah, that's a good point, E. Davis. You've asked other people on other platforms who they think Karen Reed is guilty and what evidence they feel proves beyond a reasonable doubt, and they all say she's a sociopath and there's overwhelming proof, but they can't explain anything about the details of the case, the botched evidence collection. All they can say is, "Oh, she hit him. She said I hit him. I hit him." Yeah. Oh, really? Okay. Well, even if she did say that, she's in drunk state and she's feeling guilty because I don't think she really knew what happened that night because she was under the influence. and also took hard liquor, and I've seen enough cases, and I know what hard liquor can do to impair your judgment and memory. So I think the physical evidence carries the most weight, and she never said that as confession. She was just taking that as like, maybe I did something wrong. So just me insults and twisted information. That's what the Commonwealth is doing here, day in, day out, week after week after week. Body language, interrogation trial. You're saying Brian Albert states John O'Keefe was never in my house before or after that date. Brian Albert, notice in this statement it could imply John did go in his house. Yeah, that's what he testified to at trial 1. I'd bring that out on cross-examination. Or I guess he's not going to be called by the state, so bring it out in your direct. Breno O'Brien, you're saying you agree with the younger jury. You've been harassed by officers for doing nothing wrong. I feel like older people grew up to respect officers and they're there to protect. I respect them, but yeah, there's bad eggs in any profession, and you can definitely find them in law enforcement as well. Peter, first name, yeah, frame jobs are illegal. There's just too much evidence that stuff is planted, like the hair on the back of the car of Karen. That's just, hair doesn't land and stick on there. Hair's not sticky. If it's wet, the wind whipped along there. His hair wouldn't have been wet when it went flying to the car. Anyway, it's just so contrived. Linda Capps, in all your experience in courtrooms, have you ever come up against a judge like Judge Knight? No, I have not. I've never seen a prosecutor as bad as Brennan. I've never seen one as bad at the judges trying to keep out the truth and deny constitutional rights. So that's why she's in. Karen Reed and her team, they're walking into a chainsaw there. It's like they took a chainsaw to the Constitution and it's just a tribunal, a lawless tribunal. Time trap, yeah. What other murder cases has the lead investigator gotten fired and the case still goes on? You're not going to see that. Yeah, Mark Wunderlich, where did the Nike sign on John's head come from? Yeah, that's not something anybody really can explain. I don't know if ARCCA would know about something like that if they were asked. It couldn't have been any of the tail light because that had been such a blunt force. It would have crushed his skull in. And we heard from Dr. Wolf of Miami that his head did not have that depression in the part where the back of the skull was crushed. Peter, first saying no, the Commonwealth of Massachusetts is not a sovereign country. They're a state. And so all the constitutional Bill of Rights applies to the states as well as the federal government. The Bill of Rights applies to the states via the 14th Amendment. All right, it is 1 minute away from midnight. So I'm going to go ahead and sign off. So thanks for all your support for the justice cause for Karen Reed and her family. And I hope to be back on tomorrow night after a very exciting day of testimony tomorrow. So compare what we had tonight versus what we see tomorrow from Aperture's Dr. Welcher. Can't wait to see it. So look forward to covering that tomorrow night. So you all have a safe time, and we'll maybe see you tomorrow night. Thanks. Out of here.